as well.
Good evening, everyone.
Good evening.
All right. So tonight we're going to talk about duties and liabilities of realtors and contractors. You received my email with the 3 attachments. Yes?
Yes, ma'am.
Okay. Okay. All right, good. So you know that when you're getting a mortgage, a realtor and a contractor is involved from the very beginning of the process. And you know that even starting with the sales is based on contract. So it's either the mortgagor enters into a contract with the realtor or with a contractor. And the basis of those arrangements that they enter into is a contract. Now to understand as to when a person should be paid for certain services is based on the contract. So the first thing you have to understand is what are the elements of a contract? What makes a document a contract? And the essential elements of a valid contract is that there must be an offer and there must be acceptance. Now you can also have a counter offer that could be contingent with certain conditions, but you still have to have an offer and you have to have an acceptance. Now, in order for you to still say you have an actual agreement between the two parties, there must be consideration. And consideration means it must be agreed upon sum or an act that must be performed. The next element that is a part of an essential contract in order for it to be valid is that the parties must intend to create legal relations. So both parties must be in agreement that, yes, I am entering into an agreement to purchase land, or I'm entering into an agreement whereby the contractor will build my home to certain specifications. Now, the fifth element that makes a contract valid is capacity. As an individual, you have to be over 18 years of age. As a company, you must have the legal standing in order to execute a contract for a particular purpose, which means that it must have the relevant authorizations. So those are the 5 essential elements to a valid contract. And the 5 of those must be present in order for you to say you have a contract. Now, in addition to these 5 elements, there are other things that you have to consider when you say that you've entered into a contract. One is the formation, and the formation says how the contract should be set out. So you know, for a sales agreement, the typical clauses and the way it should be set out. And you normally don't deviate from that because that is the formation. And the same thing if you have a conveyance, if you have a second further charge, there is a format. The second thing is that is essential.
Let me start. I have a question.
Mm-hmm.
So you could have you were saying you could have a contractor or a realtor. Can we have both at the same time?
Yes, as long as it specifies the terms and conditions for each one.
Okay. Like
Yeah.
if a realtor shows you an unfinished property, normally
Mm-hmm.
wouldn't you would have to get a contractor as well, right?
Yes, because
Okay.
they have to be paid.
Okay. And then if you find a property without a realtor, then you just work it with the contractor
Yes.
and the
But
owner.
yeah.
Okay.
But it
All right.
depends on how you do it. If you're financing it through the bank or you're paying for it out of your pocket.
So if I'm doing it out of pocket, I don't need a contractor.
How are you going to build a house?
Well,
Whoever,
that's true.
right? Even if you're getting someone to do it piece, like how we were discussing in the classes, you still need to enter into contract.
Okay.
Right. And just be very careful. If you don't seek legal advice, you've been in this class and you understand that there has to be an offer and have to be acceptance. So let's just say you want him to take the house up to Belcourse. He looks at the plans that you've drawn and he say, this is going to cost you $25,000. When you draw up that contract and the contract says $25,000 and you sign that, one, you have accepted his price. The consideration is he's going to perform the work. So in the contract, he should say how long it will take for him to do so. If he is smart enough, as you will see later down, there are other provisions he can put in, like if he's billing it and if that is it during the hurricane season, as to how much delay he's going to include in the contract. Then you have to be mindful. When you sign that contract, both you and the contractor must be of the same mind, which means that we are entering into a contract to take this house to Belcourse. That's creating legal relations. Both minds must be talking about the same thing. So you don't go to a contractor talking about build the bell course, then talking about roof, then talking about adding on, moving the cesspit here, moving this there. Because at the end of the day, when things do not turn out right, that's where you're gonna have problems. It has to be clear. Both minds must be thinking and arranging the same thing. And then of course, capacity. Now, if you're dealing with a contractor and you notice from yourself that they're just not getting it, because you know, some people are not as smart as others. He may be good at his work, but not smart at what you want him to do. You need to take that into consideration before you sign that contract, being aware of what you see. Because then he may come back and say, but that's not what you said.
Makes sense. That makes sense.
Okay, so those are the 5 essentials. Without those 5, you don't have a contract. And that's how a lot of people sign these documents and not realizing that they have not entered into a contract because both parties are not on the same mind. Or you signed it for 25, but in your mind you're saying, okay, let me let him start and I could drew him down to 20. It doesn't work that way. Once you sign that, you have agreed to that price. So whenever you enter into a contract, the contract has to be for a service or performance of an act that is valid. That means that whatever that service or act is, it has to be something that can be enforced by law. It cannot be for something illegal. The terms and conditions for both parties must be in the contract. So you're looking at the purpose for entering into the contract. What are the duties and responsibilities of both parties? What are your obligations? And of course, if there is any legal liabilities that may occur, who is paying for what? Do you go to arbitration? Do you go to mediation? You must put those clauses within your contract in the event that there is a dispute. Then discharge. How do you want the contract to terminate? What events can cause the contract to say, we're bringing this contract to an end? Some contracts are worded, let's say you're doing your house in stages and you're doing it out of your pocket. Your contract can be written in a way whereby when this stage is finished, when the bell course is up and the inspection has taken place and everything is in order, the contract comes to an end. Then when you want him to do the next phase, maybe in the next 6 to 8 months or 5 months, you enter into a new contract. Versus if you get a mortgage, you just have one contract with the stages in the contract. Now there are remedies, and the remedies speak to when the contract comes to an end before time. What can you do? And we'll go through the remedies. And then there are limitations. Which action can be taken on the contract, what you can and cannot do. So always be mindful of those 5 elements when you're talking about entering into a contract. And then also be mindful of formation. Most documents have a standard format. And you tend not to deviate from that standard format unless you're putting in some additional clauses. And then of course, privity of contract. Privity of contract means that only the parties that signed that contract can sue on that contract. So if you're building a house with a friend or brother and they did not sign on a contract with you and the contractor, then they cannot bring an action. That's what privity means. Only the parties to the contract can bring an action on that contract. So how do you discharge a contract? And it can be done in 4 ways. One is the parties can agree that the contract is discharged when it's supported by some consideration. So let's take again, you're building your house up to bell cost. You enter into a contract. Once that house reaches that stage and it is satisfactory, and saying that it is satisfactory, you should put that in the contract, because he can just bill it and then go. And then he expects to be paid. So he bills it, it is to your satisfaction, then you pay. Once you've paid, then the agreement is discharged. He's finished. Another way you could discharge a contract is by performance. So it means that based on how the contract is worded, once you have done what you're supposed to do, which means that, let's say you had to get approvals before he begins, or you have to get approvals in the middle of the construction, and he has performed his portion, he has done his part of it, inspections have taken place and is satisfactory, then the performance is complete. And the contract is done. Now, a contract can also be discharged if there is a breach. And a breach means that there is a fundamental condition in the contract which was not carried out. And that means the innocent person who is aggrieved can sue. And by bringing an action, then you're saying that the contract has been discharged. And the fourth way is by frustration. And frustration happens when there is some event outside the control of the parties. So it can be one person may have died, one person may have had a stroke. There could be a hurricane. The hurricane was supposed to come just for a day or 2 days or 3 days, and it ended up like Hurricane Dorian with total disaster. And all of these things means that the contract has been frustrated. The parties cannot fulfill their obligations. Or sometimes it's based on the non-occurrence of an event. So say if you're waiting on supplies and the supplies never arrived, that means that the contract has been frustrated. Now there are remedies to deal with when there is a breach of a contract. And your remedies can be by common law, or it could be by equitable remedies. Common law means that the person who has been aggrieved may seek for damages. So normally in a contract, the contractor would put in 4 damages. You can apply for an action for an agreed sum. So say the contract requests a price to be paid for goods or services. Like say if the contractor damages your marble tiles, or purchase the wrong tiles, not meeting your specifications, as would have been annexed in your contract. Or you can also see quantum meria, which means as much as it is worth. So you have 3 remedies under common law. But when damages is not enough remedy in order to I guess, to comfort the aggrieved person due to the breach, the court comes up with other remedies. And one is specific performance. And you'll see that sometime between a realtor and a client who wishes to purchase property. The court can order that the other party perform their part of the bargain. So if your part of the bargain was that you were going to sell this property, the court can order that that be done. That's called specific performance. Or the same thing with a contractor. You were supposed to complete a certain portion of the building and you haven't done so, based on the evidence before the court can order specific performance, which means get it done. Now you can have an injunction, and that's where the court will prevent someone from doing something. So the court tells you at that point in time, stop, until we have made up our mind as to what are the next steps. You can have a rescission, and that's where there's a court order, and it terminates the contract. And it places both parties back in the original position they would have been in before the contract was entered into. And the fourth remedy by equity is rectification. And that's where the court would correct a matter that is written in the contract. So it could be verbiage that is not clear, or it could be a misunderstanding with words. And the court will rectify it by correcting it. Any questions on contracts? No?
Good evening, sorry I'm late.
Okay, good evening, Tony. No questions on contracts? Okay, let's turn to the realtors now. The Bahamas Real Estate Association has made it clear that the use of the designation realtor is limited in scope and reserved only for those persons who are qualified to be called realtors. And they have a statement that says the word realtor is a copyrighted trademark of the National Association of Realtors. The National Association of Realtors has successfully taken their sole right of its use all the way to the US Supreme Court. Any member of an affiliate association, such as BREA, is entitled to join the National Association of Realtors. Then and only then will you have the right to use the word realtor. Unless this applies to you, you are breaking the law when you refer to yourself as a realtor, when you use it in your promotional materials or use it on your website. Similarly, BREA licensed agents are welcome to join the Council of Certified Residential Specialists, the CIPS Council. This alone does not give you the right to use these designations. Only if you have completed the coursework and electives, submitted your application, and received written confirmation of achieving your designation can you use any of them. So real estate agents often act on contractual basis with the vendors or purchasers of property in a real estate transaction. And they are paid commissions, normally on the gross price for the sale or purchase price of the property, which are earned when the cash is deposited and or a written agreement has been made between the vendor and the purchaser. So the real estate broker is permitted to charge and collect a commission on the total cost of the purchase price, the property at a private sale, at an auction, or foreclosed property sale. So who could tell me when is commission earned by a realtor?
Commission is earned after the sale, right? I have a question, by the way.
Okay, go ahead.
Yeah, after the sale, that's when commission is earned on the gross sale. But my question is, I know I think realtors is like 6%.
Go back to that. Go back to that. You sure?
Okay.
You sure that's
mean,
when commission is earned?
On the gross, on the sale, right? On the sale of say, let's just say it's like you buy it for $100,000. The realtor will get the 6% from that.
Mm-hmm. But what I just finished telling you about the contract.
Based on the contract, whatever percentages are stipulated in the contract.
Okay, Remember what I said, to have a valid contract, you must have what? Offer, acceptance, consideration, intention to create legal relations, and what's the last one? Capacity. Okay, so commission on sale is earned and payable when the minds of the seller and the buyer have met on the terms of the sale, as evidenced by the cash deposit.
Oh, okay. Right.
This has already begun.
Okay.
Okay, all right. Next question.
But my question was, I know in the book it has like the 6% for non-vacant property and 10% for vacant property, but is that hard in stone? Let's just say a certain property is hard to sell. Can a realtor pretty much go to the owner and tell them they need 8% for this non-vacant land?
As far as
non-vacant property?
Looking on BREA's website, BREA says the commission on sale of developed property is 6% of the gross sale. Commission on the sale of undeveloped property is 10%.
And that's set in stone. Like a realtor can't say, I want 12% because this property is so hard to sell.
No, because it's right here on the association website.
Okay. All right.
Yeah.
Ms. Archer, can that be changed? Because I mean, I'm saying you did say is a contract as an agreed as an offer and acceptance. So so as long as they put it in the agreement or in the offer and the acceptance of say I want to do 12% instead because of whatever the situation is, instead of the regular 10%, as long as you accept that, isn't that the same thing?
I think they have to abide by the rules of BREA.
Okay, I thought it would have been something like it might have been the minimum they could charge.
No,
or the maximum or the minimum they could charge is up to 10%.
Okay.
All right.
Hold on, I'm
I think it's a
commission rates. Let me see. Developed property, 6% of the sale. All real estate are based on the total gross sales of property, not on equity or partial payments.
So my thing is, Ms. Archer, I can't go in and as a realtor and say, okay, I'll do this for you, but instead of the regular 10% because of the situation where it's located and all this other stuff, to sell it, it's going to be a little difficult. I want 12% instead of 10%. Would you agree to that?
I note for you for next class from the realtors, if that is how it works.
No, I'm saying because I'm just saying as long as you say it's an offer and acceptance.
But why would you do that? If you know that the going rate is 6%, why would you go for 10 or 12?
But I don't even think especially if you're going through the bank wouldn't even allow that. They would actually have to stay with that standard 10% when it comes to like with the vacant land. And if it's like, let's say I have a realtor, someone is assisting me and I see this property that I want, and the person who actually, the realtor who is selling it for the seller, they actually have to split it half. It has to be 5%, 5%. Like nobody could say, hey, well, I want 10, and this person said they want 10. No, it doesn't even work like that. They have to, with that half, it have to be standard. Like they can't go against it.
No, but I'm thinking at the end of the day, it's the attorney who disperses the funds because the bank actually pays the attorney. And the realtor commission comes either from the attorney when they disperse based on whatever the contract says. So I don't think the bank would have anything to do with that.
But don't forget now, you are borrowing money from the bank. Would they actually allow you to enter an agreement where the realtor is charging you 12%, 14%?
Especially if it's not by law, I don't think they'd allow that.
That's an agreement. That's an agreement between you and the realtor. The bank is only. I'm thinking the bank is only looking at the cost of the property. If they say as long as it's within the thing, whatever you all agree to at the end of the day, we said we can pay based on the appraised value of the property, the $100 and some $1,000 or the 50,000 or 80, whatever the amount is. And then we pay the attorneys. The attorneys, in fact, then disperse the funds to the vendor to the vendor, to whoever needs to be based on whatever. The bank doesn't have anything to do with the realtors per se.
But doesn't the bank has an obligation to do their due diligence when it comes to their clients investing? Let's say if they know it's wrong, they know that the percentage it's standard at 10%, but the realtor is charging more. And don't they have an obligation to at least say something to say that, well, we can't allow this because this is a standard fee, and the realtor is going, against whatever the standard percentage is. I think they have an obligation as well.
We had that question a couple of weeks ago in one of our classes. They don't have the obligation to inform the buyer of it. Remember, we just had a case where the woman bought the car from somebody, and the car was like, they don't have that obligation based on what I was being told. So at the end of the day, they don't have to.
But I still think this is a bit different, though.
I don't see the difference, because property is property. Whether it's a car is a property or the property is property, it still is. You understand? So I mean, it still come up the same way.
But I think you have to notice this is a legal document which they treat legal work differently. So the bank does have some obligation when it comes to the buyer in reference to that sales agreement, because normally they view that and they look for that 10%. So if they see anything higher than that, they're gonna note that and ask why.
That's what I say. I think they would flag that.
A chattel is different from an equitable mortgage.
Okay.
With an equitable, the bank is liable because we have to pay attention to whatever the lawyer tells us.
Okay, but I'm just thinking, as long as it's a contract, and if I agree into a contract with a realtor, and we say, okay, we'll do 12%. I'm still thinking it's still a contract. Ms. Archer just said it is a contract. It has to be an offer and acceptance. Now, if I accept that at that point in time, whether it is what I mean, whether.
But Bria rules.
Wouldn't they be able? I'm assuming they would be able to lose their license for that, though.
Yeah, because they have license. They have a legislation that they follow.
But not if they inform the individual. That's what I'm saying.
I'm going.
If they inform the individual, they say, hey, look, it's usually 10%, based on our rules or whatever. It's usually 10%. But because of the situation, I'm thinking it's going to be a little hard to do. I may have to go around and try to do this and do extra. So I'm going to ask for 12%. Okay? I'm asking you for 12%.
If their rules and like legislation and policy says that they have a limit, they can't even contract out of, like, you can't, employment law, for example, the employer's legislation, you can't contract out of laws stipulated by legislation. So if they have like regulations and stuff that guide them that say 10% max, they can't even contract out of that. Even if somebody agrees to it, you can't agree to something that is against your legislative right. So, I mean,
Okay.
I don't know. I don't know if
that ends that then. Okay.
Okay.
I'm not sure if it says 10% max though, but I'm saying if it does.
That's right.
But like you said, as long as it's legislated, and if it's legislated as 10% max, then that's it.
Right.
Yeah, right. But I'll find out from the realtors if they can go higher.
Okay.
Okay, I'll find out for you. That's not a problem. Okay, so I gave you the 10% and 6% at the bottom there. So there are some general duties of a real estate broker or agent, and they have a duty to follow and act on their clients' instructions in a timely and responsible manner and in accordance with the terms that are laid out in the contract. They have a duty to act in good faith and in the best interest of their client. They have to act in a professional manner, a duty to act in a professional manner. They also have a duty to account for all monies paid to or entrusted to them for deposit in a property transaction and any client monies generally. And of course, they have a duty to disclose any conflict of interest in the execution of their duties. Now, the contractors. We have the Construction Contractors Act 2016, and that provides for the registration and licensing of construction contractors, the regulation of their conduct and practices, a disciplinary board for complaints against unscrupulous or dishonest contractors, penalties for infractions, a rating system for skills for constructing different types of homes and buildings. And the Act also provides for a dispute resolution system and incorporates a mediation and/or arbitration process for the settlement of disputes between clients and their contractors. So a contractor has some general duties, just like how the real estate agent has duties. He has a duty to follow and act on his client's instructions, and of course, in accordance with the terms in the contract between himself and the client. He also has a duty to act in good faith. He has a duty to build or construct the dwelling place in a safe, secure, and professional manner, taking into consideration the relevant health, safety, construction, structural, and other risks. He has a duty, like the realtor, to account for all monies paid and entrusted to him for the construction of the dwelling house, and to use such monies for the purposes for which they were advanced or appropriated by the client. They also have a duty to disclose any conflict of interest in the execution of their duties. And they have a duty to exercise good workmanship in the construction of a dwelling house or building to the standard required by any law, regulation, or building code established in the Bahamas. So if you go to the Construction Contractors Act, let me go to the part. Anyone on section 15, anyone who wants to be a registered contractor has to be licensed, and they have to apply to the contractors register. And they have to satisfy certain qualifications in order to be registered. Now, what are those qualifications? An individual is entitled to be registered, section 10, in the relevant section of the contractor's register, if upon his written application to the board for registration as a contractor, he satisfies the board in relation to the category set out in the first schedule. So if you turn to the back of the act, you will see the first schedule. So the first schedule, that's on page 27 of the act. It gives you the categories for registration of contractors. So you could be an air conditioning contractor or HVAC contractor. You could be a commercial building contractor, a civil marine contractor, a drywall contractor, electrical contractor, elevator contractor, fire alarm system contractor, fire suppression system contractor, a fuel or volatile substances contractor, general contractor, a light landscape contractor, liquefied petroleum gas contractor, masonry contractor, mechanical contractor, owner builder contractual, a plumbing contractor, a painting contractor, a roads contractor, roofing contractor, swimming pool contractor, utilities contractor, and any other trade that the board may from time to time deem to include. So let me ask you all a question. When persons come as a contractor, do you check to see if they are registered as contractor on a particular category?
You should check.
Yep, you should check. Okay. Now, in order to be registered, you have to obtain certain. Go ahead.
Is it mandatory for contractors to be on this list? Is it something that's mandatory?
Now, let's see if it speaks to being mandatory. I know this is the way going forward in most jurisdictions. When you call yourself a contractor, you should be registered. Let me see it. I don't remember them using the word mandatory. No, it doesn't say that. It just says that a contractor may be registered under the Act in any category set out.
But if
Go ahead.
I'm assuming if the bank is letting you the money, lending you the money, I guess they would have to be registered. I would assume.
I will
I don't think
so.
I don't think they would take that risk by lending their client a certain amount of money to someone that is not registered or certified or not, or don't really have any paperwork. I doubt it.
And then it gives you the criteria for which you are applying, and they tell you the experience and education that you should have. And the Act also calls for continuous learning. So it says under section 11, every individual wishing to be registered should make application before the board in writing and should furnish to the board proof of their identity and residential status in the Bahamas, the documents conferring their qualification and experience to fall into one of those categories, proof that they have complied with the Consumer Code for home builders in relation to the requirement to be covered by the Builders Defects Compensation Scheme, which must be renewed annually if he is a builder, and any other particulars that are prescribed by the board. If the individual is not a Bahamian citizen and they make an application for registration under the Act, they must obtain all the necessary approvals under the National Economic Council. And then the board takes 90 days to consider your application. And the board doesn't have the right to refuse you if you have a criminal record, as long as you have not reoffended within 2 years before bringing in your application. Now, you can be temporarily registered for a period not exceeding 6 months if you meet certain qualifications. So once you meet the requirement for the contractor, for the category that you're applying for, you will get a certificate of registration. And that certificate is subject to certain conditions as the board may determine. A certified copy of the certificate of registration is evidence in any court that the individual to whom the certificate relates is a registered contractor. And the same thing if the registrar gives a letter to the court saying that a certain person is not a registered contractor. Any individual who claims to be a certified registered contractor, they should display their certificate in their office or their place of work. So once you are an individual and you want to be licensed as a contractor in any year, you have to apply. You have to satisfy the qualifications and you pay the prescribed fee. You have to submit your certificate of registration as prescribed, and you have to produce evidence to the board that you are an existing client with a locally licensed bank in the Commonwealth of the Bahamas. You also have to produce your public liability insurance for a minimum of $1 million. So you see, this is also geared towards those big projects that go before the National Economic Council. So any firm who wishes to undertake work or as a contracting firm in any year should apply to the board for a license and state in the application that the work will be carried out under the supervision of a licensed contractor. And that licensed contractor has to be named in the application. They should have the authority to submit bids on behalf of the firm. Their name does not appear on a license issued under the subsection of another firm. And they possess a current business license. And the licensed contractor has coverage under the Builder's Defects Compensation Scheme. And they have to be able to provide proof that they can obtain public liability insurance in the amount of $1 million and any other particulars. So the license number of a licensed contractor or a licensed contracting firm shall be specified by the contractor or the contracting firm, as the case may be, in any newspaper or other media advertisement, any telephone directory, or in any correspondence from the contractor or the contracting firm. And their license has to be renewed annually. The registrar should keep a register of licensed contractors. And the contractors have to give evidence of their insurance. And then the act spells out what is professional negligence by the contractors. Repeated performance of defective work in which adequate checks have not been applied. Undertaking work which he is not competent to perform by virtue of his training and expertise. Failure to correct or report a situation that he believes may endanger the safety or welfare of the public. All of these are grounds for professional misconduct. And so whenever there is a complaint, that individual against a registered contractor under the act, and they've been found guilty of professional misconduct, the complaint can be made to the board in the prescribed form, accompanied by affidavits. And the board can exercise its disciplinary powers and appoint a disciplinary committee to review the complaint. And depends on the outcome, you could have the registered contractor can be suspended, or their name can be removed from the register. So once you're suspended or you're removed from the register, your certificate of registration should cease to have effect for as long as the name remains off the contractor's register, or as long as the suspension is in force. And of course, you can be restored to the register. Any questions? No questions on the Construction Contractors Act? The next act that came into being, that was 2016 and 2019. We have the Environmental Planning and Protection Act. And in that act, it states at section 11 that no person shall commence work on any project unless that person has been issued a certificate of environmental clearance in accordance with prescribed regulations. If you commence it without that certificate, the fine is $500,000 or 1 year in prison or both. Or if it's on conviction, it's $10,000 or 3 years in prison or both. Now, the environmental policies call for the Bahamas to develop a national environmental policy framework. And the policy framework is based on ecological, economic, social, and cultural realities in the Bahamas. And it includes a description of the environment, an analysis of environmental issues of national significance, the environmental management strategies to address the issues of national significance, and the obligation of the Bahamas in relation to international environmental agreements to which the country is a party. And the policy framework incorporates the protection of the ozone layer, the reduction of emissions from greenhouse gases, and the National Persistent Organic Pollutants and Toxic Chemicals Management Policy. All of these set out in international treaties that the Bahamas are signed on and ratified. The national policy will also include national water quality management, the National Air Quality Management Policy, a national beach and coastal area protection and management policy, a national forest plan, a national coral reef conservation plan, a national biodiversity strategy and action plan. So all of these are part of the to be settled by the Minister for Environment. The act also states that every person has a duty to maintain and protect the environment. And no person can authorize or permit any activity that has an adverse effect on the environment unless the activity is regulated in accordance with the act or the regulations. And every person has a duty to inform the director of any activity that may adversely impact the environment. So the duty of the department is to promote environmental best practices. And the department promotes environmental awareness, educate the general public on environmental matters and concern, promote the use of environmentally friendly products, monitor, prevent, regulate, and control contamination or pollution from any source, advance any other activity prescribed to facilitate the protection of the environment. So the act goes more into a lot of different areas. When you have large projects that go before the National Economic Council. So I know you've heard a lot going on for quite some time on the Disney project. They had to prepare a impact assessment. You recall that? Nobody does?
Yes, ma'am. Yes, ma'am. That was when they
Okay.
wanted to do some work.
Yes, so Disney Cruise Line Illustra project is in its final stages. This was in 2021. They selected for the establishment of a housing subdivision for Bahamians in Eleuthera at a cost of $10,000 for single family parcels of land and $15,000 for multi-family lots. This was a $400 million investment in a cruise terminal and island resort getaway. The developers at that time had completed their environmental impact assessment, and the environmental management plan was being reviewed by the Department of Environment, Protection and Planning. The environmental impact assessment and the environmental management plan were carried out with great care and diligence at a cost of approximately $6 million. And then once the management review process was completed, Disney and the government would then proceed to the groundbreaking. Now, of course, they missed out a step, because after they would have submitted the impact assessment and the management plan, of course, they have to go through the whole review process and issue a certificate. So if we go to the regulations, the regulation says that no person shall commence or proceed with a proposed project until they have a certificate of environmental clearance. And any person who intends to carry out a proposed project should make application for a preliminary review of the proposed project in the form prescribed in the legislation. The director shall examine or cause to be examined the documents for accuracy and completeness, and shall determine whether an EIA, an EMP, or further studies are required. If the director is not satisfied that he has sufficient information, the director may give notice in writing for the project proponent requesting such additional information as the director considers necessary. So whenever a director considers that a project that's going before the NEC needs an EIA or an EMP, whoever is the person that had was Disney, they have to prepare and submit electronically and in writing the EIA and the EMP to the director in the form prescribed in the act. They will get a decision back from the department within 60 days. If the director is satisfied with the EIA or the EMP, then of course, the process moves on. But where the project is satisfied that the proposed project does not require one, then of course, the certificate of environmental clearance is given and it moves on to the next step to the NEC. So once the EIA or EMP has been submitted to the director, the project proponent gives notice in the newspaper and in general circulation, stating that the consultative process in respect of a proposed project has been completed, that an EIA or EMP has been prepared in respect of the proposed project, that the EIA or the EMP has been submitted to the department for review, and there's a date, place, and time where you can obtain a copy of the EIP or the EMP free of charge to inspect it. The Department of Environmental can or should also give to the general public, interested parties, no less than 2 weeks notice of a consultative process to be conducted by the proper proponent regarding a proposed project. And you can give your written comments back to the department, and the Department of Environmental will then send those comments to proponent to see whether or not they need EMA. So after the certificate of environmental clearance has been granted, the department, of course, will continue the project oversight, and they will oversee the project EIA or the EMP or the conditions of the certificate of environmental clearance. They will document the progress of the project and its compliance, and they will give a final sign off upon completion of 3 years of full development operations. Whoever is the project proponent, they have to faithfully implement the EMP, including any conditions that are set out in the environmental clearance. The Department of Environment will monitor the implementation of the EMP and the environmental clearance. So in addition to all of that, the project proponent has to make a deposit. It's a bond deposit, and that sum can be fixed by the director and is normally 5% of the value of the project. Now, this performance bond can be paid in cash and deposited to the Environmental Administration Fund, or that 5% can be secured by an indemnity insurance, which will be assigned to the department until the activity to which the bond relates ceases, or the development is abandoned or decommissioned. Or the third way is they can secure it by a guarantor, and that guarantor has to be through a reputable financial institution. The period of the performance bond would be for the period from the start of the project and 3 years of full development operations. If the bond is not used after substantial completion and 3 years of full development operations, and the project proponent is not in arrears, the bond will be returned to the project proponent with interest that was accrued, if any. If the bond was used during construction, the unused portion is returned to the proponent, the project proponent. Now, the Department of Environment has a duty to publish a website for the department. And on that website, they should approved EIAs and EMP once they have issued the certificate. And of course, the project proponent can go to the director and advise where there are certain parts of the EMP that EIA that they think is confidential. And if the director agrees, those information will not be disclosed to the public. Any questions? And the act gives you the outline for an environmental impact assessment, an outline for an environmental management plan. So this is an additional step that was put in before the National Economic Council gives an approval, where you must have an EMA and an EIP. So the environmental impact assessment for Lighthouse Point, it states that Disney Cruise Line is creating a new experience in Eleuthera at Lighthouse Point. The destination will create sustainable economic opportunities for Bahamians, protect and sustain the natural beauty of the site, celebrate culture, and help strengthen the community in Eleuthera. It will complement Castaway Cay, a Disney destination located in the Abaco chain of the Bahamas, giving families the opportunity to enjoy the site's beautiful beaches and explore nature, as well as enjoy the broader tourism offerings in Eleuthera. It says, we have spent an unprecedented 3 years developing one of the most comprehensive EIAs ever produced for a project in the Bahamas. Along the way, we have engaged with hundreds of stakeholders and experts throughout the Bahamas, whose thoughtful feedback has enabled us to continue to evolve our plans. As we have said from the beginning, we will only move forward with the project at Lighthouse Point if we're able to do so in a way that aligns with our company's deep and long-standing commitment to the environment. The EIA has confirmed this will be possible with the appropriate environmental management plan in place. So what's the project design? Open trestle, pier, and small marina that do not require dredging, art and culture center, walking paths and beach areas with beach chairs and cabanas, food and beverage and merchandise locations, back of house support areas and service roads, 190 acres of land donated back to the people of the Bahamas, newly constructed public roadway, access to the site, including the southernmost point for Bahamian residents and citizens for non-commercial purposes. Now they also publish the key EIA findings. It says here that the development and operation of a proposed Disney Cruise Line destination at Lighthouse Point isn't expected to result in a loss of terrestrial or marine biodiversity. No unique marine habitats or species have been documented to occur within the proposed development footprint compared to other areas of Eleuthera or the Bahamas more broadly. Based on surveys using the globally recognized Atlantic and Gulf Rapid Reef Assessment, coral reefs do not appear within the footprint of the open trestle pier or marina. The impact to terrestrial species is expected to be minimal given the low density nature of the project. The salt ponds on site will not be developed. Some historical ruins were found in an area of the property where no development is planned. The project is not expected to have a material impact on climate change. DCL is employing sustainable building practices, and there is not expected to be a loss of marine or terrestrial biodiversity. DCL plans to protect the significant investment in the project by using design and building techniques that would enable it to withstand impacts due to climate change. And then it goes on and it speaks about proposed mitigation for the environment. It speaks about the economic impact and of course the shareholder engagement in the Disney project in Eleuthera. So that's a good example to see the act in action. Since they were the first ones to have to go through the process of getting approval. Any questions? You all should be excited about this act because that means there's less damage is being done to our reefs, our coral reefs, our ruins, our water supplies, our forests. And there are a lot more projects on the table. So you're going to be seeing much more environmental impact assessments. As people come in to develop the islands. So the last thing in your notes is the similarity between the Real Estate Brokers and the Construction Contractors Act. So you can see that both have the normal style of legislation where there's a short title and interpretation. Both speak to the establishment of the respective boards. And then in part 3, the real estate qualification required to register as a real estate broker or salesman. The Contractors Act speaks to the registration of contractors and the qualification, their registration, and the licensing of contractors and renewal. The same thing under the Real Estate Brokers is speak about their re-registration, renewal, and both speak to the financial provisions. Saying that both referring to service, the real estate broker and the contractors have discipline measures put in for suspension, removal from the listing or from the register, and of course, restoration to the register or restoration back to the listing. Penalties under both pieces of legislation, and the normal process is there are appeals to the Supreme Court for any aggrieved party. Any questions? Silence gives consent. No questions. So if there are no questions, we are done for tonight. Is everyone asleep or awake?
Awake.
Awake.
Any questions, comments? No, none whatsoever.
Well, my only question is, will this be on the test?
Of course it will.
Okay.
It'll be one that it'll be there somewhere. We'll discuss that on the last day, not next week, the Monday after that, when I write the exam. It'll be in some way, some form, somewhere, tucked somewhere in some question. You wouldn't have to know that much, I don't think, at this point. So next week, we're going to look at the legal and credit risk for property mortgage transactions. So with that said, have a good evening. You get off early tonight. I hope you're reading your cases. Yes?
Yes, ma'am.
Yes, ma'am.
I started.
Got it. Very good. Very good. You see, you only have 2 more weeks and then it's time to get ready for that test. All right. So have a good evening and continue reading.
Good evening.
Good evening.
Good evening.
Good evening.
Good evening.
Good evening.